Pag-uusapan natin ngayon ang karanasan ng ibang bansa pagdating sa age of non-liability, juvenile delinquency at youthful offenders. Ito ba ay pareho sa batas natin dito sa Pilipinas? Ito ba ay makatutulong sa ating mga kabataan para maging mabuting mamamayan? Ang mundo natin ngayon ay may kinikilalang restorative justice, kung saan kapag nagkamali ang isang bata ay hindi kaagad ikukulong, kundi bibigyan siya ng pagkakataon na malaman ng kanyang pagkakamali at para humingi na rin ng kapatawaran. Sa ganitong pananaw ay nakikita ng mga eksperto na ang isang bata ay pwede pang bumalik sa mainstream society. Ano nga ba ang makukuha nating aral sa mga bansang sumubok nito? Yan ang ating alamin dito lang sa Patakaran.
Health is our most important asset, and it's
Good evening to everyone. It is a pleasure to be here at Suffolk Law School, and I am with an adjunct professor, a retired judge, justice of a juvenile court. We have here with us Steve Lyman. Good evening.
Good evening.
Judge, good evening.
Nice to see you.
It's a pleasure to be with a colleague, a professor of law, and I think you would want to know also that Professor Lyman was a Peace Corps volunteer in the Philippines. When was this, Professor?
1968 to 1970.
Wow, for 2 years he was in the Philippines. That's why he is a Filipino by heart. And kindly take note that he's an adopted son of
Gumaca, Quezon.
Gumaca, Quezon, and that's fully documented. He has shown that to me.
That's when I was a 16-year-old AFS exchange student.
Oh, wow.
To Gumaca.
And prior to that, you were an exchange student likewise in the Philippines. Is that correct?
That's where I was the exchange student.
Wow. And that was in what year?
That was in 1963.
And I recall on the side prior to this interview, Professor Steve mentioned to me that his visit to the Philippines was a life-changing experience, right?
Exactly right.
And why is it a life-changing experience?
A couple of reasons. First, I was planning to go into medicine before I went there. And when I got there, I had the pleasure of meeting the first Peace Corps volunteers ever in the Philippines or anywhere in the world. They started in 1961, so I met some of the outgoing volunteers, and then I met some of the incoming volunteers, and I thought to myself, this is a really nice place, and when I graduate from college, maybe I can come back as a Peace Corps volunteer. Okay. And after both of those experiences, I decided that international law, or at least law, was going to be my career and not medicine.
Oh, wow. So it was the Philippines. His Philippine experience changed his life direction.
Yes.
Now, having said that, why have I invited Professor Steve? I wanted him to join us because of his expertise in juvenile justice. and has been a judge, juvenile justice
24
judge
years.
court for how long?
24 years.
24 years. And that's a lot of experience.
It's a lot of years.
That's a lot of years. And please tell us, in your jurisdiction here, what does a juvenile court judge do or justice do?
We have three areas of jurisdiction.
Yes.
One, and the one that's most well-known, is over delinquency, which also has a second part, which is youthful offender cases. We also do cases called children requiring assistance, and those are young people who have cases not brought against them, but because they need assistance. And so we're looking at young people who are disruptive in the schools, or who don't go to school, they're truant, or who disobey their parents at home, or who run away from home.
Does not follow directions of the school.
Either they don't follow the directions of the school,
Or their
and they
parents.
disrupt the school, they disrupt their homes by running away or by not following the rules.
So that's treated in what category?
Those are-
Is that a case? Will that become a case?
They're brought as children requiring assistance cases.
And who brings the action?
Well, the school, if it's a school-based
Oh, really?
situation, or the parents, if it's a home-based situation.
So
And what we explain to them is this is not brought as a case against you. It's brought as a case on your behalf to try to figure out why the behavior is occurring and whether there are services that might help you to overcome those behaviors.
and how the government could assist them in
Exactly.
changing and be better citizens of the community.
Exactly.
Wow. And the third jurisdiction?
The third are, we call them care and protection cases. Those are cases brought against parents or other custodians who have abused or neglected their children.
This time, it's an action not against a child or a delinquent or a youthful offender, but an action instituted against the custodian.
Right, against
The
the
guardian,
custodian on behalf
parents.
of the child who is being abused or neglected.
And who will institute the action? The child? Who will assist the child?
We have a statute that says that there are mandated reporters. And so the mandated reporters essentially are any professional who has contact with children. So teachers, nurses, doctors, police officers, firemen, psychologists, psychiatrists, anybody who by their profession has contact with children is a mandated reporter. And if they have reason to believe that a child has been abused or neglected, they are required to report to the state agency, which is the Department of Children and Families.
Okay. And the state agency will then in turn do what?
They will investigate to find out whether the allegations are substantiated. And if they are, they will start a case in the juvenile court. And we have the ability to try to make sure that the department is providing opportunities for the parents to change their behavior and change their attitudes.
So it's the parents, the guardians, or the custodian. Now, let me ask you this. What is the ultimate relief sought against the parent, the guardian, for neglecting the child?
Well, there are a number of outcomes. One is that they change their behavior,
That's one.
and therefore reunification is the outcome. The second is that they might be found to be unfit parents.
And if they are determined or asserted as unfit, what do you do?
Then we can place them in the permanent custody of the state, or we can place them in a guardianship with
This is the child.
the child,
Okay.
with another family member or a relative or a teacher or somebody who wants to care for them.
How about a religious institution?
Religious institution could do it, but it really is to a person within an institution.
Okay.
So it might be a high school coach, it might be somebody in a religious institution, it might be a teacher, it might be somebody who cares for them.
So the judge, like you, can make such an award.
If we adjudicate a parent or parents to be unfit parents,
Yes.
then we are obliged to do an outcome that is in the best interest of the children.
Okay.
So we have several people who make recommendations to us, and then we have to determine what outcome is in the best interest of the child.
So aside from bringing the child to a family that cares or to someone who cares, the parent is trying to be corrected. And so
Or may not be trying to be corrected.
Or have you seen an experience or have you seen a case wherein the parent was united with the child
Yes.
at some point? Yes.
So it happens, yes. And what typically happens is the Department of Children and Families that initiates the case in the juvenile court works with the parents for about a year to give them opportunities, to give them services designed to correct the behavior, the deficiency, the parental deficiency.
If the parent is not corrected or the deficiency was not addressed, what happens?
Then the department usually says, we want a trial to determine that the parent or parents are unfit.
Okay.
The department is trying to prove that they're unfit at that stage. They're working with the parents to try to solve the problem. But if they get to the point after giving them enough time, the parents aren't doing it. They're not working.
Okay.
Then the department will come in and say it's too late. Children need permanency and they need it as soon as they can have it. And therefore it's time to say these parents are not going to get it. And we are going to adjudicate the parents to be unfit, and then we're going to ask the court to do a disposition that's in the best interest of the children. The final thing that we can do, the ultimate thing that we could do, is ultimately to free the child to adoption, for adoption.
Eventually for adoption.
We can terminate parental rights and free the child for adoption.
So, in a sense, they will be separated from each other.
They might be at the very beginning.
Okay.
They might be put in foster care.
Even at the start of the investigation.
At the start or somewhere near the start. And they can be in foster care until the department or the judge believes that it's safe for the children to go home. Even if the parents have not yet really turned their lives completely around, if it's still safe for the children to go home, we might reunite, or the department might reunite. More often, the reunification doesn't happen until the parents prove their fitness.
Have you seen instances wherein parents have physically abused children? Having physically abused them, they hit these children, and are there imprisonment or are there penalties for parents like this in the United States?
There are, but not in the juvenile court. We don't have jurisdiction over parents except in care and protection cases where we're looking at parental fitness, not penalties for what they have done to the child.
So actions for these types of cases or for these types of, let's say, crimes or felonies will have to be filed in a different court?
Yes.
Okay.
And the department might contact the local police, or the local police might have been the mandated reporters who came to the home to prevent some behavior that was going on that they found out about, and when they found out about it, they then would call as mandated reporters to the department to report the parents.
Okay, I'm very curious about the word reporter. Is any person, an official, a public officer, a designated reporter? Should they be officially appointed? Should they be designated by the government?
Our statute has mandated that anyone, a professional, not just state actors, but any professional who has contact with children as part of what they do, is a mandated reporter. They are obliged to report if they believe that children have been abused or neglected. Now, you or I, as non-mandated reporters, also have the right to pick up the phone and say, I believe that my next-door neighbor's children are being abused or neglected. And in either case, whether it's a mandated reporter or someone else, the department will investigate.
So I could be a reporter?
You could be.
Okay. Now, I would want now to lead our discussion to that concept of delinquency, youthful offenders, right?
Yes.
And non-liability.
Yes.
Please help us on this. I would like, we have our own system in the Philippines. Non-liability in the Philippines is below 15. I would want to know, in the state of Massachusetts, what is the age of non-liability?
Okay, just so that I understand, non-liability means you might have done something which, if you were an adult, was considered a crime, but you are not arrested and you do not face the consequences in a courtroom.
Exactly.
Okay. So our non-liability until about a year ago was children under the age of 6.
So that was before. Okay, a year ago.
Yes.
That was before 6.
It now is under the age of 12.
Now, when you say under the age of 6, 6 and below.
6 and below, they're not arrested, they're not subject to any possible delinquent liability.
So if a child, let us say, a child, 5 years old, 4 years old, commits a crime, the child is not liable.
Correct.
Okay. Now, let's try to move forward. Let us say, today, it's 12 years.
Yes.
12 years and below. Before the amendment, okay, if a child is age 8 years old and he shoots someone, that's a crime.
It is.
And under the present law, now, there's non-liability for a child below 12 years and below.
Yes.
So what happens? The child simply walks away.
Yes.
Really?
Yes.
He goes home. He doesn't get to be arrested.
He does not.
Oh, okay. He goes back to his family.
If possible, if he shoots someone in his family might not want the child, in which case the Department of Children and Families might intervene.
So, Professor Steve, this is regardless of the gravity of the offense.
Yes.
So it could be murder, it could be rape, it could be robbery, it could be theft. So all of this, if that is the age of the child, no liability.
No liability.
That's very clear. Now, that is today, 12 years and below. Now, from how about beyond 12 years? Okay, that's still a child.
Our maximum age of delinquency
Yes.
is 18.
18. Okay. So you're telling me above 12, but below 18
Yes.
is the age of delinquency.
Yes.
Can you please explain this to us?
Okay.
Who are those considered as delinquents? I know that it is not just because of age. Okay, but again, an important consideration is the age of above 12 but below 18. But who are considered as delinquents?
They are young people who have done some act which, again, if they were an adult, would be considered a crime. So those can be as light in terms of consequences as shoplifting
Okay.
or trespass,
Trespass?
or as serious as anything up to the point of murder.
Okay.
So manslaughter would be a crime that might be committed by someone between the age of 12 and 18 with consequences as a delinquent.
He's a first-time offender. He's a first-time offender. He committed a crime, let's say robbery, or let's say manslaughter. What happens? Is he arrested, investigated, and brought to trial?
All right. If the police see the offense, they have the right to arrest.
Even if the age is in between above 12 and below 18?
Yes.
Okay.
If it is not seen by the police and it's considered to be a felony, they can arrest as soon as they get enough facts to lead them to believe that there's probable cause to arrest. If they do not see it and they don't have probable cause to arrest, then they can go to court and apply for a complaint, and the child is not arrested, but can be summoned to court. And then the court determines whether there's probable cause to initiate a complaint.
So this is a criminal case.
It is a delinquency case.
A delinquency case. Now, in a situation like that, an action has been properly instituted, depending on the nature of the offense. What is there, can we say, a penalty, or what can the court award, or what can the court do in situations where there are actions against delinquents?
Similar to adult cases here, we have a whole range of things that can be the consequences of being adjudicated a delinquent. At the upper end, if the crime is serious, or if the child is committing a series of acts, then the maximum sentence that a juvenile court judge could impose is commitment to the state agency that deals with penalizing children by locking them up. That agency is called the Department of Youth Services. So they have locked facilities, and they also have some temporary homes.
So what they do is they detain. Can we say they detain this juvenile, this delinquent?
We call it being committed to the department.
They are committed, but this is not really. This is not really in prison.
The prisons look a lot like adult prisons.
Oh.
There are a couple of things that is different.
Yes.
There is education that goes on inside.
Okay, so they cannot go home. They are detained, but they are educated. They are.
That's right.
Educated.
There's
they're given
physical
education.
activity. There are
Yes.
libraries. They may learn a skill.
Yes.
So those are all things that go on in the juvenile correctional agency. And then it's up to the commitment is to the Department of Children and Families to the age of 18. We don't set the term of years that they actually spend inside the institution. The Department of Children and Families can, at some point before they get to the age of 18, release them to their homes.
Even if they're delinquent, even
Yes.
a crime has been committed.
Yes.
Okay.
And that release to their homes is done conditionally.
Okay. So when you say release, the determination of whether or not they are to be released would be before they reach the age of 18. Before they reach the age of 18.
So the sentence is, I commit you to the Department of Youth Services to the age of 18.
Okay.
You're in their care and custody to the age of 18. They can release you home to the street with conditions.
And then they will have to determine or ascertain when they reach a certain age whether or not they will have to be released. Okay?
Right.
Or what if the assessment there is by the authorities that he has not improved? But before you answer this, magbabalik po ang Patakaran.
When visiting the Philippines, Manila or Quezon City is a popular destination. But oftentimes the hustle and bustle of the city can be more stressful on your vacation. So when you feel the need to reconnect to nature or relax again, there's a beautiful oasis just outside of the city called the Garden at Ciudad de Victoria. Some of the species that you can see here include hydrangea, snapdragon, and stargazers. They're truly beautiful. The gardens at Ciudad de Victoria are so peaceful, tranquil, and beautiful that it's become a haven for young couples and a very popular venue for engagement photos. The next time you want an escape from the big city, the garden at Ciudad de Victoria is a wonderful place to visit.
Nagbabalik po ang patakaran. Professor Steve, as I was saying a while ago, what if the child reaches the age of 18? What happens to the child? And should the child be released?
The child is released at the commitment age of 18 unless the judge is asked by the Department of Youth Services to extend it for a year because he has not been rehabilitated.
So the thing is, if we're talking of delinquents from the age of 12, above 12 and before 18, it's only until 18 years of age.
If they are committed to the
Yes,
Department
if
of
they
Youth
are
Services,
committed.
it's to the maximum age of 18, possibly extended for another year to 19.
But it could be less than 18. Could it be, is it possible that, let's say, he committed it at the age of 14 and that he'll be released at the age of 16? Or does he need to complete 18?
That's up to the Department of Youth Services.
Youth
They
Services.
determine what the child has to do when he is in the institution.
Okay.
If the child does what he is expected, or she is expected to do, then the department can release conditionally to the home. If the child then does something and
Then he will be
reoffends,
recommitted.
he can come back to the department doesn't have to wait for the judge to adjudicate again.
Really?
The original commitment is to the age of 18. If the child reoffends, that's breaking a condition.
They'll just bring...
They can go and bring him right back in.
Oh, okay. Now,
He can then be he can be recharged, and we can do the whole adjudication process on the second charge, but he's already committed to the department to the age of 18.
let's look at this. The child already reached the age of 18. And the department is not convinced that the child has changed. And he may pose a danger to the community. They could extend it for a year, right?
They can ask the court to agree with them that the child is a danger.
Yes.
And if the court does, the court can extend for another year.
Another year. What if after a year, then again the child did not change? What happens? Should the child be released?
The child is released.
Oh, really?
The child is released.
The status of a delinquent really is very important, because that process, those years of commitment, the direction is really to try to change the child.
Yes.
Just to change it. Now, and that is for first-time offenders, right?
No, that's for anyone.
For
most children are not committed to the Department of Youth Services.
Why do you say most children are not committed?
Only a very small percentage, probably less than 5% of children are actually institutionalized, actually committed to the Department of Youth Services.
And why is it a very small number of children?
Because the juvenile delinquency system is designed to try to keep a child out of an institution, finding ways to reform their behavior outside of an institution in other ways.
So let's talk about that.
Okay.
Let's talk about reformation later on. That is why there are just a few children.
Reformation can be a very formal process.
That's right.
But it can also be being placed on probation with a probation officer, with the court setting conditions. The probation officer is then in charge of making sure that the child follows those conditions.
Okay, if I may interrupt. So a child who is above 12 and below 18, okay, can be placed under probation.
Yes.
And when a child, because in my jurisdiction, when you talk of probation, there is already a sentence.
This is a sentence as well.
In your jurisdiction, there's already a sentence. So the judge renders a sentence and then places the child to probation.
Yes.
Under probation. Okay. And how do you do this in your jurisdiction? To placing a child in under probation? Will there be probation hearings and all?
There first is an adjudication. So there's either a plea.
Yes, a plea of guilty.
A plea of being adjudicated a delinquent.
Oh, so that's how
we
it is.
distinguish between adults who are convicted
Right.
and juveniles who are adjudicated to be delinquent.
Okay. Adjudicate. So a plea to be adjudicated as a delinquent.
Yes.
And then,
if at the end of the adjudication, or it can be an adjudication by plea, or it can be after a trial.
Yes.
And in fact, for young people, it can be a jury trial.
Okay.
So after an adjudication by plea or by a finding of the court or jury, then one of the sentencing options is being placed on probation conditionally. The judge sets the terms and conditions of probation. The probation officer is the person who monitors the juvenile during the time of probation.
So the child will have to visit the probation officer.
Yes.
designated days of the month.
That's correct, and the probation officer has the right to contact the school if one of the conditions is attend school.
Okay.
Then the probation officer can call to make sure that the child is attending
What
school.
if the child violates the probation?
Then the probation officer can file a violation notice.
And then?
Then the child is summoned back into the court before the judge, and there's a
And the child could be jailed?
there's a probation violation hearing. The probation department reports and calls witnesses to show what.
So there is really a probation hearing.
There's a probation
Before
hearing.
it is canceled or annulled, the judge will get to hear
Exactly.
whether there is a good reason to cancel the probation.
Exactly, and if there is,
Yes?
then we can sentence to the Department of Youth Services, or instead of a probation sentence, we can commit to the Department of Youth Services and give the child a suspended sentence. So,
Explain that suspended sentence.
Okay.
So he will be committed until he reaches 18.
right,
Right.
which sentence we will suspend for, let's say, 2 years or 3 years
Until
with
he reaches
conditions.
21.
No, before the age of 18.
Before the age of
We're committing them to DYS to the age of 18.
Okay.
With that sentence suspended before the child reaches the age of 18 with conditions.
Okay.
So now we set perhaps different conditions from the ones that have been violated.
At the time.
And again, if there's a violation, probation officer brings the person back, we have a probation hearing, and if the child has violated those conditions, then I can revoke the suspension and he's committed to the Department of Youth Services to the age of 18.
Till the age of 18.
Yes.
Now, once he reaches the age of 18, what happens? Considering that he violated the probation.
Again, if while in the institution the department believes he's dangerous, they can come back to the judge and ask the judge to extend that commitment to the age of 19.
Okay.
That's
Now,
it.
Then he has to be released.
Released at 19.
So there's
18
no
or
way,
19.
there's no way by which a person or a child committed in youth service, Department of Youth Service, can have a sentence just like of an adult, that of an adult.
That's correct. In an adult case, the judge sets the term of years or months
Right.
that the person is to do time.
Correct.
In the juvenile court, all we can do between the ages of 12 and 18 is say, I'm either not committing, and we're doing pre-commitment kinds of dispositions, or I'm committing to 18, and then it becomes up to the Department of Youth Services to decide when the child gets out conditionally.
Now, I would like to ask you this question. How about youth offenders? Because to some, they think that a youth offender is the same as a delinquent. Okay, what's the difference?
Okay. There's a specific statute that deals with youthful offenders. And the definition of youthful offenders is a child between the ages of 14 and 18.
Okay, hang on. This is a different age. Delinquent is above 12, but not exceeding 18.
Right.
Right? For youthful offenders, age of 14 to not exceeding 18.
Yes.
Okay.
The second is that they have committed a felony.
Okay.
In Massachusetts, a felony is one of the more serious crimes.
And therefore, the penalty for the offense exceeds 2 years.
Then the penalty. Then we'll get to the penalty.
Okay,
We're just
okay.
defining. We're just defining
Good.
youthful
Okay.
offender. So the definition is between 14 and 18. The present crime is a felony.
Right.
And then one of two other things. If the youth is formally committed as a delinquent
Right.
to the Department of Youth
Youth
Services, or the present crime either involves serious bodily harm or a threat of serious bodily harm to the victim. So if the offender, whether it's at this point he's not a youthful offender, he is considered to be a delinquent child unless the child falls into those four categories. And if he falls into those categories, then the prosecuting attorney, the district attorney, can decide to indict the child.
So he will be actually indicted.
They'll go to the
Yes.
grand jury, the child will be indicted, and the indictment comes back to the juvenile court, and the child is treated as a youthful offender.
Okay.
So several distinctions between the
I would want to hear that.
between the
delinquent
and
the
the
youthful
offender.
offenders.
The first is, unlike delinquents who have a closed hearing, that's designed to protect young people against the stigma of criminality.
It's not open to the public.
It's not open to the
Okay,
public.
so a
Most of these
delinquency
kids are
hearing-
going back home, and when they go back home, we don't want people saying, "Oh, look,
you
that's-
have committed a crime. I
Right.
saw you in court."
Exactly.
Okay.
Exactly. So it's not open to the public. Youthful offender cases are open to the public.
So youthful offenders, anyone could drop
Anybody,
by.
including the
I
media.
could observe.
Anybody can come in, including the media. Second, delinquents have a right to a jury trial. Massachusetts is one of only, I think, 6 states that have jury trials for delinquents.
Okay.
And they have a right to a jury of 6. Like adults who commit lesser crimes and go to the district court
Right.
have a jury of 6.
All right.
Youthful offenders, like adults who commit serious offenses and go to superior court, they have a right to a jury trial, and it's a jury of 12.
Okay. So there's even a difference between a jury of 6 and a jury of 12.
Again,
Yes.
it's like the adult, where
Right.
the less serious crimes have a jury of 6 in the district courts, the more serious crimes go to the superior court, jury of 12.
So for youthful offenders, it's already a jury trial of 12 individuals.
Yes.
Okay. The next distinction.
The next is sentencing. Sentencing.
Oh, okay.
So we just talked about a delinquent child having a maximum possible sentence of commitment to the Department of Youth Services to the age of 18.
That's right.
A youthful offender can also receive a commitment to the Department of Youth Services, but the maximum is to the age of 21.
So a youthful offender can likewise be committed to the Department of Youth Services, but it could go beyond 18.
Right, and remember, like the delinquent, the judge loses control over how long
Yes.
the young person is in the institution. It's then up to the department to say, you committed at 15 as a youthful offender, you're committed to 21, we can keep you here until 21, or we can release you to your home with conditions.
But again, that's a decision of the department.
Correct.
Okay, not the judge anymore.
Not the judge. The next option is we can sentence the youthful offender to any sentence that an adult court judge can sentence an adult to for committing the same
So
offense.
just like an adult.
Just like an adult. The only distinction is we do not have murder 1 or murder 2 jurisdiction. But any other crime, manslaughter, rape, anything else, we have the ability to sentence that person to any sentence that an adult could receive in adult court
And
for
that
the same
could-
offense.
That could be sentenced by a
By a juvenile court judge.
juvenile court judge. Yes.
The third option is a hybrid between the two. So this sentence is commitment to the Department of Youth Services to the age of 21, but we want to give the youth extra incentive to do well while he's in the Department of Youth Services facility. So we then say is you're committed to DYS to the age of 21, but I'm also imposing an adult criminal sentence
Of so much.
of so much, which will be served after you finish your DYS commitment to the age of 21. So what we're saying to the young person is, we want to give you extra incentive to do well when you're in commitment, because if you get out and you commit another crime, then you can be brought back in, and after a probation hearing to determine whether you violated the terms and conditions of your suspension,
Right.
the judge can remove the suspension and you can go into the adult facility.
Let me ask you this. Let us say that the child was committed, the youthful offender, and then when he reached 21, let's say it's a hybrid sentence, and then he will be serving after the age of 21.
Yes.
Okay. Now, let us say while they're committed inside the Department of Youth Services, they saw a great improvement, and there was a recommendation. Would it be possible the department will make a recommendation that he no longer serves the sentence?
If he's committed to the Department of Youth Services and he's serving that commitment to the age of 21,
Yes.
the judge is out of the picture.
No, what I'm saying is that there was already a previous award, a sentence,
Yes.
that says after this reaching 21, you will have to serve 2 or 3 years more in just like a regular offender.
Yes, then he's no longer in the Department of Youth Services. Now he's serving his sentence in an adult facility.
And that cannot be withdrawn anymore.
It cannot be. Then it's up to the parole board, which releases adult people who are incarcerated
Yes, because of good service.
prior to the end of their sentence.
Okay. So I hope you understand that it's getting a bit complicated, but we're really trying to be very, very simple about it. And I think our televiewers are able to understand what it is. Now, let me ask you about something which is very interesting at this time, which is what we call restorative justice. But before you answer this, magbabalik po ang Patakaran. Nagbabalik ang Patakaran. Professor Steve, as I was referring or asking you a while ago, what is restorative justice?
There actually are two things that are done to help a child who has allegedly committed a crime to avoid being arrested, in some cases, in other cases not, or totally avoiding the system entirely.
Right.
The first, at least here in Massachusetts, we call diversion. And diversion can
And I recall, if I may interrupt, in my jurisdiction, there is also such a word as legal term, diversion.
It may very well have a different meaning.
It may have a different meaning. Please explain.
Okay. So in Massachusetts, and each state has its own system, so I'm talking only about Massachusetts.
Yes.
In Massachusetts, diversion can happen in one of two ways. It can be judge-controlled diversion,
Okay.
or it can be prosecutor-controlled diversion.
Okay. What's the difference? And how would we know that it should be a judge-controlled diversion or a prosecutor-controlled diversion?
Okay. Prosecutor-controlled diversion is where a child has been arrested and the prosecutor is involved,
Right.
and the case is about to be arraigned in the juvenile court, and the prosecutor has criteria for determining when prosecutorial diversion is appropriate, criteria that they have established, not judges.
Not judges.
And they can come into the court and say, Judge, we think that this is a proper candidate for our kind of diversion.
So that child, okay, will not be brought to trial.
If the judge accepts the
Yes,
recommendation, then we will say this can happen in one of two ways. It can be pre-arraignment, in which case
That's very important.
In which
It
case
is
there is no
before-
record whatsoever.
Yes, that's before arraignment or after he has been arraigned.
Or it can be after. Now, there's a separate kind of diversion which actually has been institutionalized by the legislature just several months ago.
Okay.
And this sets out certain kinds of cases. And if a child is brought into the court system, again, prior to arraignment,
Yes.
and the clerk is about to issue a complaint, and it falls within those criminal complaint areas, where the legislature says these children can be diverted out of the system by the judiciary, then they don't actually issue the complaint. The child is brought before the court.
That is the discretion of the judge.
That's first the discretion of the clerk's office to decide whether or not the criteria are met.
Okay.
And they do not issue the complaint. They bring the child before the judge and they say, this is a child who's committed an offense which could be diverted.
And
it falls within the criteria
criteria
established by the legislature. And it's up to the court to look at the situation prior to arraigning on the complaint to determine whether judicially we agree.
Okay. And whether he could be subject to diversion.
Correct.
Now, we have mentioned diversion a number of times. Can you please explain to us how it happens? How it happens? Because diversion may be very technical to some televiewers, but how does actual diversion take place?
Okay. Again, one of two ways. If a police officer sees what he believes to be a crime,
yes,
in his presence, or if it's a felony that is not, he has the ability to either arrest the child,
yes,
or to seek an arrest warrant.
okay.
And therefore, the case comes before the court as an arrested case.
Yes.
But if the prosecutor decides that he or she wants to invoke prosecutorial diversion, they can then undo that arrest.
Okay.
The child does not have an arrest record, and they can come before the judge and say, we believe this is one of those kids who falls within diversion.
And who participates in the diversion? Is it the prosecutor who talks to the child?
Prosecutor,
Who else?
the probation officer will try to get information that will be presented to the judge to determine whether it falls within the prosecutorial guidelines for a child who should be diverted.
And the intention of the diversion is to change the child.
It's designed to try to find a way to change the child without involving the government system, the
prosecution,
judiciary.
the judicial system.
Right. So if it's prosecutorial, they have services out there, and
Right.
they try to engage the child in those services. And if after whatever the prescribed period of time is by the prosecutor's office, the child is doing well, then it's dropped.
So
they never
there-
bring the child to court.
And there is no case.
And there is no case.
And that is the concept of diversion.
Right. If it's judiciary diversion, it's the same thing. There's no complaint. We've undone the arrest if there was an arrest. And the court has services that we ask the child to participate in. And if the child does a good job, then that case is never, there's not an arrest.
It's not even docketed.
It's not docketed.
Docketed.
And there's no record.
And there's a hope that the child will change because of the programs
Because of the
under the
services.
diversion program.
Exactly right.
Now, how about, I've heard this fairly recently.
Restorative justice.
Restorative justice. And I think I heard it from you. And I'm
You did.
very interested about this. Can you give us a little idea of what
Yes,
this is?
I knew that there was a thing called restorative justice, but I didn't really know very much about it.
Yes.
And I was sent to lead a delegation of 6 people to Ireland. We went to Dublin in Southern Ireland and to Belfast in Northern Ireland. Both of those places have restorative justice programs. And we were introduced to what they do there and how they do it.
How do they do it there?
And this is all directed by the police. They call it the Garda
The
in
Garda.
Ireland. Yes,
Okay.
but they're the police. They're the police officers in Northern and Southern Ireland. If they come to believe that a child has committed a crime, it can be in their presence or somebody can complain. They then call the parents
Immediately?
immediately.
But
They do
how
not-
will they get hold of the number?
They talk to the child. They'll take the child to the police station, but
Right.
they do not consider that to be an arrest.
Right.
Because what they do is they ask the child, who are your parents? What's your phone number? We need a way to contact them. They get in touch with the parents. If they can't, then what they'll usually do is drive the child to the address that the child gives us the home
Really? With
and
the
to
police?
find out
Yeah.
where the parents are and get the child home. And the intent is to talk to the parents about whether they want the child arrested.
So it's now the parents' choice.
Do you want your child arrested because we have the right to arrest? We saw the child committing the offense, or we've heard enough to lead us to believe he's committed an offense, or she. Or would you like us to treat this through restorative justice? And then they explain what that means.
And what does that mean?
What that means is that there are all of the state agencies that deal with kids have agreed with the Garda, the police in Northern and Southern Ireland, that they will participate in a way of determining what the child needs to turn the behavior around, to prevent recidivism.
So it is a desire to change the child even before they're made part of the process.
Right, and it's kind of like diversion, but it has some benefits.
What's the difference?
Well, let's get into that.
Yes.
Well, first, it's police run.
Unlike here, prosecutor and court.
That's right.
Diversion. Yes.
And the police, and the responsibility of the police officer is to inquire of the parents. Do you want us to treat this formally by arrest and taking the child for arraignment in court, or would you prefer to do restorative justice?
Okay. If the parent says, "No, I don't want my child to be arraigned,"
They will try to convince the parent. We don't want the child to be arraigned?
Yes.
Then they'll say, then we will engage in restorative justice. We will have your child triaged by all the child agencies that deal with providing services.
This is some sort of a committee or
Right, somebody representing all of those agencies. They talk to the police, they talk to the child, they talk to the parents, they try to get a sense of what the child needs. They offer those services.
Yes.
The police then monitor the provision of those services and whether the child is engaged in
For how
those
long
services.
will the police monitor?
Usually it's a year.
It's a year.
Usually it's a year in Northern and Southern Ireland. At the end of the year, this is the other difference. There is a meeting between the victim and
Really?
the child perpetrator.
So the victim and the offender,
Yes.
the child offender.
And they sit like you and I are sitting,
like here?
with nothing in between them.
Yes.
So there is no barrier between the two of them.
This is the best example of restorative
It
justice.
is exactly what goes on.
Yes.
The victim explains the impact on the victim and the victim's family. After hearing that, and probably knowing it in advance, the child responds. And usually it's in the nature of a major apology about causing those things, about what the child has learned, and about why this is never going to happen again.
And why it has changed his life.
And why it's changed the child's life. And the parents are sitting there. The police officer who started all of this
The process.
and who guided the process is sitting there. And I had the pleasure of sitting in on one of those.
Can you please share that with us?
I will tell you, it was one of the most powerful things that I've ever seen in my life.
Yes.
I saw a police officer who was the victim,
Yes.
who was monitoring a dance at a local school, and saw a child get off a bus intoxicated and went over to help. And the child wasn't just intoxicated, but what she was drinking had been doctored with some drugs, and the child was out of control. And the child shoved this police officer downstairs. The officer was standing at the top of a concrete stairwell.
Wow. And by the child pushing the police officer,
Fell
what
down
happened
the
to the
stairs,
police officer?
broke both of the officer's legs, and that was a formerly world-class athlete who would never be a world-class athlete again. So I saw this police officer telling what the impact was. She was out of work for 6 months.
Right.
It impacted the family. It impacted the sport and her team that she was a member of. All of that was heard. And then the child gave a from the heart
So they met a year
discussion.
after.
Yes.
And then what did the child say?
What she learned, what she learned about what she had done that night,
Right.
what she learned about drinking and meeting people and taking drinks from people who might talk to them,
Right.
about playing within the bounds of the law, treating police officers with respect, doing what you need to do to finish your education so you can go on for a better life. And this was a good student who herself was an athlete.
Wow.
So she was able to say, I saw what might have happened to me if I didn't finish school and I fell into the wrong hands, or if something went wrong, I would no longer have an education, I would no longer be an athlete. And then she really sincerely apologized. Wow. And then they engaged the parents to say, and not only that, but we're going to be staying on top of our child to make sure that she follows her promises.
This is a complete turnaround.
Yes.
So while there were injuries suffered, while there was pain, but again, there is a child who after a year was able to rehabilitate and to change and be a better member of
and
the community.
and to convince the victim
Okay.
of those changes.
Now, Steve, I would have wanted, we could speak about restorative justice for the next 2 hours. And, I know that you have explained it very well. And I'm very glad that you're here with me. And I would like to thank you.
It's my pleasure,
Okay.
my friend. It's
My
my
friend.
pleasure.
And I would like to thank retired Judge Steve Lyman, a Filipino by heart. Hanggang sa susunod na linggo, ito po si Attorney Tranquil, dito lamang sa Patakaran.
Sandigan Bayan ang pagproseso sa mga record ng kasong graft ni Ilocos Norte Representative Imelda Marcos. Ito'y matapos mabigyan ng due course ang notice of appeal ni Marcos kung saan hiniling ng dating First Lady na iakyat sa Korte Suprema ang kaniyang kaso. Ito'y kaugnay umuno sa binuong Swiss Foundations na pakikinabangan ng pamilya Marcos. Una rito ay nakapagpiyansa si Marcos para sa kanyang pansamantalang paglaya. Sa resolusyon ng Anti-Graft Court, dahil sa edad at kalusugan ang pinagbatayan kaya nabigyan ito ng provincial liberty. Hinatulan ng guilty si Marcos sa kanyang 7 counts of graft at sinintensyahan ng 6 hanggang 11 taong pagkakakulong sa bawat bilang ng kanyang kaso. Hiniling ng Department of Justice sa Manila Regional Trial Court Branch 5-1 na gawing state witness ang kapwa-akusado ni Kerwin Espinosa na si Marcelo Adorco sa kasong may kinalaman sa droga. Ayon sa DOJ, malaking tulong ang mga naging testimonya ni Adorco para magsilbing direktang ebidensya ng prosekusyon. Isa si Adorco sa mga sinampahan ng kaso sa paglabag ng Republic Act 9165 o Comprehensive Dangerous Drugs Act kasama sina Espinosa, Peter Co, Lovely Impal at iba pa. Kaugnay nito, naghahain ng motion to discharge ang DOJ sa korte sa kaso ni Adorco at paboran ang pagiging state witness nito. Ibinasura ng Sandigan Bayan ang apela ni Gigi Reyes, ang dating Chief of Staff ni dating Senador Juan Ponce Enrile na makapaglagak ng piyansa sa kanyang kasong plunder. Sa 253-page decision ng Anti-Graft Court, ibinasura ang motion for bail dahil sa kawalan ng merito. Sa MR ni Reyes, may pagkakamali ang Sandigan Bayan nang ibasura nito ang kanyang apela. Hindi rin umano nakapagpresenta ng kumpletong ebidensya ang prosekusyon sa kanyang bail hearing. Pero giit ng korte, walang merito ang mga argumento ni Reyes. Pinirmahan na ni President Rodrigo Duterte ang First 1,000 Days Law o ang Kalusugan at Nutrisyon ng Magnanay Act. Layunin ng batas na sa unang 1,000 araw ng isang bata hanggang sa mag-2 taong gulang ito ay matugunan ang lahat ng kanyang pangangailangan para lumaki ng maayos at malusog. Ayon kay Senator Sonny Angara na author ng nasabing batas ay makakatulong rin itong protektahan ang mag-ina laban sa malnutrisyon at iba pang malulubhang sakit.
Subaybayan ang bagong news programs ng Net25. Agila Balita, Washington DC edition, tuwing Lunes mula alas 7 hanggang alas 7:30 ng umaga. At Eagle News International, Filipino edition, Martes hanggang Biyernes mula alas 7 hanggang alas 7:30 ng umaga. Lalong pinalakas at pinalawak na pagbabalita. Eagle News Service, as we live in interesting times.
Sa mga nais magtanong tungkol sa mga suliraning legal na wala pa sa hukuman, Maaari kayong mag-email sa patakaran.tbc@gmail.com o maglagon sa aming Facebook at Twitter accounts. Maaari din kaming mapanood via live stream sa www.eaglenews.ph. Kailangang busising mabuti ang mga batas sa Pilipinas pagdating sa juvenile delinquents, youthful offenders at age of non-liability para mapagtuunang pansin ang mga kabataan upang sila ay magbalik loob sa batas. Kailangan din nating tingnan ng mabuti ang age of non-liability para malaman kung tugma sa aktual na pangangailangan. Hanggang sa susunod na linggo, ako po si Attorney Tranquil Salvador III. Basta't laging tandaan, sa bawat karapatan ay may patakaran.